right after the giving of the false testimony, the heirs of the victim can already file a case of violation of Article 181, that is, false testimony in favor of a defendant. No need to wait for the final judgment insofar as the defendant is concerned. Again, the same is true in false testimony in civil cases. Article 183 punishes perjury. Perjury is the willful and deliberate assertion of falsehood on a material matter made before a competent officer duly authorized to receive and administer the oath. The elements of perjury are, first, that the offender made a statement under oath or executed an affidavit on a material matter. Second, that the statement or affidavit was made before a competent officer duly authorized to receive and administer the oath. Third, that in the said statement or affidavit, the offender makes a willful and deliberate assertion of falsehood. And lastly, that the said statement or affidavit is required by law. These are the elements of perjury. Based on the first element, there are two ways of committing perjury. It can be committed by making a statement under oath. It means orally. Or it can be committed by executing an affidavit on a material matter. It means in writing. Both must be under oath, and based on the second element, both must be made before a competent officer duly authorized to receive and administer the oath. Even if there was falsity in the statement, even if there was falsity in the said document, if it is not done before a public officer duly authorized to receive and administer the oath, perjury is not committed. Because the essence of perjury is the violation of the solemnity of the oath. Hence, it must be made before a competent public official. The third element requires the offender makes a willful and deliberate assertion of falsehood. Therefore, for one to be liable of perjury, there must be a deliberate intent to perjure himself. It cannot be committed or born out of mere impudence, negligence. Hence, good faith is a defense in case of perjury. Last element requires this document, this statement is required by law. In an estafa case filed before the fiscal's office, the fiscal held preliminary investigation, and he called for a clarificatory hearing. He had some issues wanting to resolve before finding probable cause, and so he called for a clarificatory hearing. Both parties, the complainant for the estafa and the respondent, appeared together with their witnesses. And so under oath, the investigating public prosecutor started asking questions. The witness for the complainant, under oath, stated falsities. Later, it was discovered his statements were all false. What crime may be filed against the said witness? He may be charged of perjury. In a labor case, under oath, X stated falsities before the labor arbiter. What case may be filed against X? Perjury. In an administrative case, being heard by the Sangguniang Panlunsod against the barangay chairman, the witness testified, the witness stated falsities. He testified falsely in the said hearing before the local Sangguniang. What crime is committed? Perjury. In all these cases, it is perjury. Why not false testimony? It is not false testimony because if the said statement under oath was done in a non-judicial proceeding, in an administrative proceedings, in a legislative proceedings, it is perjury. But if it is done in a judicial proceeding, it is false testimony. In the statements of assets, liabilities, and net worth, that the public officer submitted to his office, he stated falsities as to his assets and liabilities. What crime is committed by him? He is liable of perjury because a salent is required to be under oath. But what if this public officer stated falsities in his residence certificate? What crime is committed by him? Falsification of public document, because a residence certificate is not required to be under oath. So if the document is required to be under oath and falsities are stated therein, crime committed is perjury. But if the document is not required to be under oath and falsities are stated therein, the crime committed is falsification of public, official, commercial, private document. It depends. Under Article 184, the law punishes offering false testimony, false witness in evidence. Here, the offender offers in evidence either a false witness or a false testimony. The offender knows the testimony, the evidence is false, and he offers the same either in a judicial or any other official transaction. Offering false testimony in evidence under Article 184 is not the same as subornation of perjury. Under Article 184, the mere act of a person of offering in evidence a false witness will already give rise to the crime. The law doesn't require that the false witness that he offered be first convicted of perjury. In case of subornation of perjury, here, a suborner produces a witness, and this witness testified falsely. Before the suborner can be held liable for subornation of perjury, it is necessary that the false witness must first be convicted of perjury. So there lies the difference between offering false testimony in evidence under Article 184 versus subornation of perjury. Article 185 punishes machinations in public auctions. Machinations in public auctions may be committed in two acts. First, by soliciting any gift, promise, before any other person as a consideration for refraining from taking part in public auction. Or by attempting to cause bidders to stay away from public auction by means of threats, promise, gifts, or any other artifacts. Whether it is solicitation or attempting to cause bidders to participate in the public auction, it is necessary that the intent of the offender is to cause the reduction of the price of the thing which is the subject of the auction. Therefore, the public will be deceived. That's why it is a crime against public interest. The intent or the purpose for this public auction is that there should be many bidders, so the public will be able to get the best price. If no one is bidding, then the public will not be able to get the best price for the thing subject of the said bid. Hence, to solicit someone, to solicit a gift for one not to participate, or to attempt bidders not to participate will give rise to a crime under Article 185. Article 186 and up has already been amended by commercial law. Title 5 has been discussed to you by your lecturer in drugs, has been discussed to you, right? By your lecturer in special penal law, right? So we go to Title 6, Crimes Against Public Morals. Under Title 6, Crimes Against Public Morals, the first among these under Article 200 is grave scandal. Grave scandal is committed when the following elements are present. First, that the offender performs an act or acts. Second, the said act or acts are offensive to morals, good customs, and decency. Third, the said act or acts does not fall under any other provision of the revised penal code. And lastly, the said act or acts was committed either in a public place or within public knowledge or public view. These are the elements of grave scandal. In grave scandal, the offender performs acts which are offensive to morals, decency, good customs, where either in a public place or within public knowledge or public view. When the said highly scandalous act is performed in a public place, there need not be any witness. The place being public, the law presumes someone had seen the commission of the said highly scandalous act. If, however, the highly scandalous act is committed in a private place, the law requires it must be within public knowledge or public view. Otherwise, the crime will not arise. So, if it is performed in a private place, there must be witnesses. Someone must have seen the commission of the said acts, which is highly scandalous. The third element of grave scandal requires that the said highly scandalous act must not fall under any other provision of the RPC. Therefore, it is necessary that the said highly scandalous act would not constitute a violation of the RPC under any other provision. If it does, then the appropriate charge would be that provision of the RPC and not grave scandal. So grave scandal is a crime of last resort. You can only file a case of grave scandal if the said highly scandalous act would not constitute any other violation of the RPC. The girlfriend and the boyfriend went to the park. The girl, however, was only 11 years old. The man was already 20 years old. When they realized that there are no more persons in the park, as it was already late at night, they had sexual congress in the park. It was with the consent of this 11-year-old girl. Are they liable of grave scandal? They are not liable of grave scandal because the third element is absent. The third element requires the highly scandalous act does not fall under any other provision of the RPC. This third element is absent because in this case, when this 20-year-old man had sexual conquest of an 11-year-old girl, the man committed statutory rape. Regardless of the consent given by the girl, the man is liable of statutory rape. Therefore, the appropriate charge is not grave scandal, but rather statutory rape. Again, grave scandal is a crime of last resort. Under Article 201, there are several acts punished. Public proclamations of doctrines contrary to public morals. Then we have also publication of obscene literature, wherein here, the author, the publisher, and the owner of the establishment signing the same shall be held criminally liable. We have also another act punished is the exhibition of indecent or immoral shows, scenes, acts, in fairs, theaters, cinematographs, or in any other places. And likewise punished is the act of selling, the act of exhibition of any prints, films, engravings, paintings which are against public morals. Under Article 202, the law punishes prostitution. Prostitutes are women who, for money or profit, shall indulge in sexual intercourse or lascivious conduct. It is an act, it is a crime exclusive to women because vagrancy had been decriminalized. We go to Title 7, Crimes Committed by Public Officers. Under Title 7, Crimes Committed by Public Officers, all the felonies under Title 7 can either be a malfeasance, a misfeasance, or a non-feasance. This was asked 2016 bar exam, define malfeasance, misfeasance, non-feasance. There is malfeasance when a public officer performs in his public office an act prohibited by law. There is misfeasance when a public officer performs an official act in a manner not in accordance with what the law provides. And there is nonfeasance when a public officer knowingly and willfully omits, refrains, or refuses to do an act which the law or his office requires him to do. All the acts under Title VII can either be a malfeasance, a misfeasance, or a nonfeasance. Knowingly rendering an unjust judgment. It is committed by a judge who, in a case submitted to him for decision, renders an unjust judgment despite knowledge that the judgment is unjust. He knew the judgment is unjust. Nevertheless, he renders the same. He becomes liable under Article 204. An unjust judgment is one which is against the law, or not supported by evidence, or both against the law and not supported by evidence. Judges enjoys the so-called judicial immunity from suit. A judge can only be held liable under Article 204, knowingly rendering an unjust judgment, if he renders the said unjust judgment based on bad faith. If the judge renders an unjust judgment based on his mere error in interpreting the law, he cannot be held criminally, civilly, and administratively liable. Because judges are at liberty to interpret the law, provided they acted in good faith, and there is no evidence of bad faith, he cannot be held liable criminally, civilly, and administratively. Therefore, for him to be liable for knowingly rendering unjust judgment, it is necessary that he acted in bad faith, motivated by ill will, when he renders the said unjust decision. Judgment rendered through negligence under Article 205, again, this is committed by a judge. The judge renders an unjust judgment because of his ignorance of the law or inexcusable negligence. It is a manifestly unjust judgment, an obviously unjust judgment. You need not be a judge to know that it is unjust judgment. Yet, the judge rendered it out of ignorance, out of inexcusable negligence. He becomes liable under Article 205. Unjust interlocutory order, just like a judgment, the judge can render it either knowingly rendering an unjust interlocutory order or an interlocutory order which is unjust and rendered manifestly unjust interlocutory order rendered by reason of his inexcusable negligence or ignorance. And then we have malicious delay in the administration of justice. Malicious delay in the administration of justice is committed by a judge who delays the proceedings, the administration of justice in his court with malice. There is malice on the part of the judge when his intention is to favor one litigant and to cause damage or prejudice on the other litigant. If the delay was done by him in order to favor one and to damage one, then he becomes liable under Article 207. The dereliction of duty in the prosecution of offenses. This time, the elements are first, the offender is a public officer or an officer of the law who has the duty to prosecute or to cause the prosecution of offenses. And he commits the dereliction of duty in any of the following manner. First, knowing that a crime has been committed, he does not cause the arrest and prosecution of the offender. Or, knowing that a crime is about to be committed, he tolerates its commission. And last element, he does so with malice and deliberate intent to favor the violator of the law. From Articles 204 to 207, the offender is a judge. In Article 208 this time, the offender is a public officer who is charged with the prosecution of offenses. We have the public prosecutors of the DOJ or the special prosecutors of the Office of the Ombudsman. Or those public officers who can cause the prosecution of offenses. We have the persons in authority, agents of persons in authority. They are the ones mandated to prosecution of offenses. And yet, the said public officer does not arrest this person who has committed a crime, or he tolerates the commission of the said crime, and he did it with malice in order to favor the said violator of the law. The accused was convicted. The accused was convicted in the crime of estafa. Upon receipt of the decision of the court, the accused immediately went to his counsel. The accused told the counsel that the judge failed to look into the document that they submitted. Based on the reasoning given by the judge in the said conviction, it is evident that he did not look into their document. Had he looked into the document submitted by the defense as Exhibit 1, the judge could have realized that they are correct. And so because of this, the accused told his counsel, we have to file a motion for reconsideration. Please file a motion for reconsideration. And the counsel said, no worries. We're going to file a motion for reconsideration, but that would cost another thing. That is no longer included in our contract. And if I have to file a motion for reconsideration, I needed another 200,000. And the accused said, it's all right. I'm giving you 200,000, but please prepare the said motion for reconsideration. The said client, the said accused, gave the amount to the counsel, but 15 days lapsed. No motion for reconsideration was filed before the court, and so the judgment of the court convicting the accused of the crime of estafa became final and executory. The accused was arrested and he was placed behind bars. He was so mad, very mad. He believed the said counsel failed to perform his duty. Aside from filing an administrative case, what case may the said counsel file? Criminal case. May the said client file against his counsel. He can file violation of Article 209, betrayal of trust by an attorney or solicitor. Attorney, the counsel of the said accused is liable under Article 209. The following acts are punished as betrayal of trust by an attorney or solicitor. First, by causing damage to his client either by malicious breach of professional duty or by inexcusable negligence or ignorance. Second, by revealing any of the secrets of his client learned by him in his professional capacity. And lastly, by undertaking the defense of the said second party in the very same case without the consent of the first party, after having undertaken the defense of the said first client or after having obtained confidential information from the said first client. In these three acts, the offender, the attorney, the solicitor can become liable for betrayal of trust. The problem falls on the first act. It is the duty of the said counsel to file the motion for reconsideration. In fact, he asked another payment for it. Yet, he did not file the same. There is a malicious breach of his professional duty that caused damage to his client because the judgment became final and executory. Therefore, he is liable criminally under Article 209. In the second act, punish, revealing any of the secrets learned by him in his professional capacity and any of the secrets of his client. This refers to the case being handled by the said client. This does not pertain to any future crimes which are about to be committed. And under the third act, punish of betrayal of trust, the basis of this is conflict of interest. The said attorney has already undertaken the defense of the first client. And then he also undertook the defense of the second client. Obviously, there was conflict of interest. To avoid being held liable, before taking the engagement of the second client, he must first secure consent of the first client. Article 210 punishes direct bribery. Direct bribery is committed when the following elements are present. First, that the offender is a public officer or employee. Second, that the offender commits any of the following acts. First, by agreeing to perform or by performing in consideration of an offer, promise, gift, or present, an act constituting a crime in connection with the performance of his official functions. Or, by receiving any gift or present in consideration for the execution of an act that does not constitute a crime in connection with the performance of his official function. And lastly, by agreeing to refrain or by refraining from doing an act which it is his official duty to do in consideration of an offer, promise, gift, or present. These are the elements of direct bribery. You open here the police officer and dun sa TV may nagbigay ng bribe. Sabi ng police, yung nagbigay ng bribe liable for direct bribery. That is wrong. Direct bribery is the crime of the receiver. Direct bribery is the crime of the public officer who receives the bribe. The person who gives the bribe is liable under Article 212, and that is corruption of public official. So direct bribery is the crime of the receiver, the public officer who receives the bribe. And there are 3 acts punished. And you will note that in these acts, amounting to direct bribery, it is always done in connection with the performance of his official function. If it is not, if the bribe is given not in connection with the performance of official function, it cannot be direct bribe. There must be a connection between the said bribe and the performance of the official function. Under the first act, if the thing a public officer is being required to do is that of an act amounting to a crime, mere agreement will suffice. It is not necessary that he actually performs the criminal act. It is not necessary that he actually received the bribe. It suffices that he agrees to perform the criminal act. The same is true under the third act. The third act, by agreeing to refrain or by refraining. If the thing a public officer is being asked to do is to refrain from doing his job, an official act required of him to do, mere agreement will suffice. It is not required that he actually refrains from doing the act. It is not required that he actually receive the bribe. Mere agreement that he will not do it because of the promise will already give rise to the crime. The second act, however, differs. In the second act, before direct bribery would arise, it is necessary that there be actual receipt of the gift or present. Mere agreement this time will not suffice. Because under the second act, the thing a public officer is being asked to do would not amount to a crime. It is his duty to do it, but he doesn't want to do it without the bribe. So it becomes direct bribery. The act doesn't constitute a crime, therefore, for the crime to arise, there must be actual acceptance of gift or present. If under the first act, if after receiving or after agreeing with the commission of the said crime in the performance of his function, the said public officer actually performs the criminal act, actually committed the crime. Aside from direct bribery, he also becomes criminally liable for the crime agreed upon. And you cannot complex it. Reason is, under Article 210, the law provides that the penalty for direct bribery is in addition to any penalty attaching to the public officer for the commission of the crime agreed upon. So if he actually commits the crime agreed upon based on the bribe given, he committed two crimes. One is direct bribery and the other one is the crime that he committed based on the agreement. Article 211 punishes indirect bribery. Indirect bribery is committed when the following elements are present. First, the offender is a public officer or employee. Second, he accepts gifts or present. And lastly, the said gift or present was given to him by reason of his office, by reason of his position. In case of indirect bribery, the said gift or present was given to the public officer solely and only by reason of the office that he holds. Here, a public officer is not being required to do a thing, to perform an act. He is not required. The gift was only given to him and he received it purely because of the public office or the position that he holds. Hence, there are no attempted and frustrated indirect bribery. Reason is, this crime will arise only and be consummated upon acceptance of the gift. No acceptance of the gift, no crime is committed. Article 211-A punishes qualified bribery. Qualified bribery is committed when the following elements are present. The offender is a public officer entrusted with the law enforcement. Second, the said offender does not arrest any person who has committed a crime punishable by reclusion perpetua and or death. And lastly, the reason of the said public officer is because of the gifts, presents given to him. So that is qualified bribery. So in case of qualified bribery, it can be committed only by a public officer who is entrusted with law enforcement. And also, it is particular to crimes which are punishable by reclusion perpetua and or death. Here, the public officer, by virtue of the bribe given to him, by virtue of the promise given to him, does not arrest, does not prosecute a person who has committed a crime punishable by reclusion perpetua and or death. A case of a complaint for murder was filed before the police officers. According to the complaint filed by X, Y killed his brother in an ambush. So, this was the complaint filed by the police officers, and there was an investigation, there was truth to it. And so the police officers invited Y. When Y learned of this case, Y offered the police officers 100,000 pesos in exchange for the non-filing of the case. The police officers accepted the amount, and indeed they did not file the case. What crime or crimes had been committed by the said police officers? The police officers are liable of qualified bribery. The police officers are public officers charged with law enforcement. Here is a person who has committed a crime punished by reclusion perpetua to death, murder. Yet, they did not arrest, they did not prosecute, they did not file the case before the office of the public prosecutor, and that is because of the 100,000 pesos given by Y. Hence, the crime committed is qualified bribery. But what if the complaint filed by X before the police was that for homicide, saying in the investigation that Y killed his brother in the course of a fight? The police conducted investigation and thereafter invited Y. But so that the case would not go to the office of the public prosecutor, Y gave the police 100,000 pesos. The police accepted the amount, and indeed, they did not file the case before the office of the public prosecutor. What crime or crimes had been committed by the police? One is direct bribery under Article 210. Under what act? Under the first act. The police officer accepted the bribe of 100,000 pesos in exchange for the non-filing of the complaint before the Office of the Public Prosecutor, in exchange for the act of not prosecuting, not causing the prosecution of why. Therefore, they are liable for direct bribery under the first act. The police officers actually did not file the complaint before the Office of the Public Prosecutor. Therefore, since they actually committed the crime agreed upon, the police officers are also liable under Article 208, the reliction of duty in the prosecution of offenses. Police officers are public officers who have the authority to cause the prosecution of offenses, and despite knowledge that a crime has been committed, they did not cause the prosecution of why? That is done with malice and deliberate intent to favor the violator of the law because of the bribe given. Although direct bribery was a necessary means to commit the reliction of duty in the prosecution of offenses, you cannot complex it, again, because under Article 210, the penalty for direct bribery is in addition to the penalty attaching to the public officer for the commission of the crime agreed upon. The judge, after the hearing on this case after the hearing for this case of murder, found the accused guilty beyond reasonable doubt. In fact, you already prepared the decision, finding the accused guilty beyond reasonable doubt. But here comes the emissary of the accused who was confined at the city jail. In fact, it was the counsel of the accused, and the counsel of the accused ran to the judge in a closed-door meeting in the chamber of the judge, offered the judge 50 million pesos. He offered the judge 50 million pesos in exchange for an acquittal of the said accused ex. The judge accepted the amount, 50 million pesos, and thereafter changed his decision. So on the day of the promulgation of judgment, instead of convicting the accused for the crime of murder, because even if the evidence of the prosecution proved his guilt beyond reasonable doubt, they were able to prove the elements of murder, the presence of treachery, the judge promulgated a judgment acquitting X of the crime of murder. What crime or crime? What crime or crimes has been committed by the said judge? First, the judge would be held liable under Article 211-A. It will be qualified bribery. Why qualified bribery? Because the crime committed is that of murder and it is punished by reclusion perpetua to death. And he did not, the said judge did not convict the said accused for what purpose? Because of the bribe money of 50 million pesos. But what if this time the crime committed by the accused happens to be homicide? So the accused was charged with homicide. The prosecution was able to prove the guilt of the accused beyond reasonable doubt for homicide. The judge already prepared a decision convicting the accused of homicide. However, here comes the emissary of the said accused, giving the judge 50 million pesos in exchange for an acquittal of the said accused ex. The judge accepted it and changed his decision. On the day of the promulgation of judgment, the judge acquitted X of the crime of homicide despite the evidence presented by the prosecution proving his guilt beyond reasonable doubt. Is the judge liable of direct bribery? Is the judge liable under RA 3019? Is the judge liable under RA 7080 of plunder? Can the judge be prosecuted on all three crimes? Although they are based on the same facts and circumstances? Is the judge liable of direct bribery? The judge is liable of direct bribery under the first act. Here, the judge received the bribe money of 50 million pesos in exchange for the commission of a crime in relation to the performance of his function. What is the said crime? Knowingly rendering an unjust judgment under Article 204. Despite the fact that the prosecution was able to prove the accused guilt beyond reasonable doubt, the judge still acquitted the accused. The judge, he knew it was an unjust judgment, nevertheless, he knowingly renders it because of the said bribe given to him. Therefore, he is liable of direct bribery under the First Act, and in fact, he is also liable for the crime agreed upon, and that is knowingly rendering an unjust judgment. Is he liable of violation of RA 3019? He is liable of violation of RA 3019 under Section 3E of RA 3019. Section 3E, all the elements are present. The elements are first, that the offender is a public officer performing official, administrative, or judicial functions. The judge is a public officer performing judicial functions. That he performs an act with manifest partiality, evident bad faith, or gross inexcusable negligence. In acquitting the said accused, he acted with manifest partiality and evident bad faith. He knew it was a conviction because of the evidence presented by the prosecution, yet he ruled for an acquittal based on evident bad faith and being partial in favor of this accused because of the bribe. Last element of Section 3 of RA 3019, in doing so, he caused undue injury to any party, including the government. He caused undue injury to the private complainant, the victim of this man. And he caused undue injury to the government because of the disturbance of public order. And he also gave a private party unwarranted benefit. He gave the accused unwarranted benefit by acquitting him. Therefore, the judge is also liable under RA 3019, Section 3E. Is the judge liable of plunder? The judge is not liable of plunder. But isn't it that the amount amasses 50 million pesos? Plunder is committed by any public officer who by himself or in connivance with any members of his family, relatives by affinity or consanguinity, business subordinates, associates, shall commit a series of overt or criminal acts. Therefore, in order to bring about plunder, it is necessary that the public officer must commit a series or overt criminal acts. A series or combination of overt or criminal acts. Here, he performed only one act. Even if that amounted to 50 million pesos, it is not among those enumerated as predicate crimes under plunder. Therefore, he cannot be held liable of plunder. So he can be held liable of 3 crimes. Direct bribery under Article 210, knowingly rendering an unjust judgment under Article 204, violation of Section 3 under RA 3019. And so he argued, he cannot be charged and be held liable of all these 3 crimes because they arose from the same facts and circumstances, since he is already liable under the RPC for 210 and 204, therefore he cannot be held liable under RA 3019. Is the argument correct? The argument is wrong, because it is expressly stated in Section 3 of RA 3019 that all the acts of graft and corrupt practices enumerated in Section 3 would always be in addition to any acts or omission punished by existing laws. Therefore, RA 3019 is always in addition to any acts or omission punished by other laws. Hence, it cannot be said that there was double jeopardy, it cannot be said that there was duplicity of offenses, because the law expressly allows it. So in that case, he can be prosecuted for 3 crimes. I'm sure RA 3019 have already been discussed to you by the special penal lecturer as well as RA 7080, so I need not discuss it. We go to Article 213. Again, Article 212 is the crime is corruption of public official. Article 212 is committed by any person who makes an offer or gives any gift or present to a public officer under circumstances in which the public officer would become liable for direct bribery or indirect bribery. So corruption of public official is the crime committed by the giver of the bribe. And he may be a public officer, employee, or a private individual for as long as he is the one who gives the bribe, after which a public officer may become liable for direct bribery or indirect bribery. He is liable for corruption of public official.